happenings around the country, one day is like 1,000 years, and in this case, a couple of hours, and you would think that we're going through many, many days. So Monday, again, was one for the books, where we saw a certain thing happening as concerns the case that grips the nation's attention today. And that is the case of Albert Ajwang and his murder. And who is responsible are the questions that are being asked. The calls for Deputy Inspector General of Police Eliud Lagat to resign, to leave office, were loud. And then yesterday, mid-morning, we saw that he actually did that. And he sent out a statement saying, well, I'm going to step aside and I'm going to allow my deputy to take over. And then the day had not even gotten to sunset, and we saw what would be damning testimony from one Constable James Mukwana about actually how he was involved and who gave the orders. We're going to be going into that conversation on justice on trial, law, rights and responsibility this morning, and we have two guests, sound gentlemen, who are here with us this morning. Irongo Houghton is the Executive Director of Amnesty International Kenya, and he's here with us this morning. We've looked for him even when he was beyond borders, but now he's here, and we're short of shackling him to the floor. But he's here anyway. Irongo, good morning.
Morning. My apologies for being AWOL or missing in action for the last days. No, okay, I'll be honest. Months.
There you go.
Yeah.
You know,
it's great to be back on Spice.
Thank you so much for being here. Danstan Omari is a man who's not slept since the 1st of June. Or even before that. He has not had shut-eye for a while. And we saw him very spirited in court. And he's also here to have that conversation with us. Advocate of the High Court of Kenya, but representing a number of people in this current dispensation. Good morning, Wakili.
Good morning. The defense never rests.
The defense never rests. And the law is very clear.
Definitely for the favor of your client.
There you go. Karibuni both.
Yes.
Dennis Aseto is in Rwanda this week. And we'd like to share the proverb from Rwanda, and we'd like to hear your interpretation from both of you.
Yes. And just a few things in Rwanda. Their national language is Kenya-Rwanda. They equally speak French, English, and Swahili. Now, in 1994, there is the genocide that happened in Rwanda. Over 800,000 people died. Continues to be a focal point in Rwanda. Hence, the reason why when you're in Rwanda, it's just the Rwandese people. There are no tribes or languages because you know what that happened. But then again, in that country, in Kenya, we wanted to see a laptop for every child. In Rwanda, it's actually a reality. Every child has free laptop provided for by the country. Now, our proverb of the day: he who doesn't flee the riverbank gets eaten by a crocodile. He who doesn't flee the riverbank gets eaten by a crocodile. Start with you, Akili. What do you make of that?
Crocodiles live within the water. What borders a riverbank? If you don't leave when the crocodile has targeted you, it will maul you. Mm-hmm. You will be meat, a dish for those crocodiles. Mm-hmm. Meaning that avoid unnecessary risks. Don't just take some risks. In law, it is called volentin and fit injuria. Mm-hmm. That if you have decided to put yourself in trouble, let nobody complain. It is your own problem. Mm-hmm. So we are being told from Rwanda as a country, if we see problems, let us keep away from those problems. Well, let us not plunge into the waters where the crocodiles are, and we know very well the crocodiles are there. This is our country.
Indeed.
Houghton?
So I was in Rwanda last week, actually, in Kigali for an East African Philanthropy Conference. And one of the things that I did after the conference was visit the Campaign Against the Genocide Museum. And this is a museum that I didn't know existed, but it was, of course, there is the Genocide Museum, which many people, including many Kenyans, have gone to. But this is a particular museum that looks at the role of 600 RPF soldiers who mounted the resistance against the Interahamwe and the Rwandese government at that time. And they did that from the parliament. And it's a story that's not well told, but I was really, moved by the courage that it must have taken to do that. I think what I get from the proverb is probably two things. One is that the danger is not only in the water, right? So once you're in the water, wrestling with a crocodile is very difficult. It's important not to lose your guard or to not be vigilant when you're out of the water, because that's the place where you can probably protect yourself most. So I think the analogy for Kenya, or the lesson for Kenya at this time, is really ensuring that we do not push this country to the brink, particularly as we move towards the elections, that the electoral architecture is put in place. And then particularly, I think, for the subject of this morning, the criminal justice system is really in the dock itself. And I think what we have to say is that, we need to see sharper reforms. We need to see deeper actions taken, not just by the National Police Service, but also by the Interior and by the independent offices. We can talk a bit more about that. I have a friend that says, don't ignore the lizards, for one day they will grow up to be crocodiles.
And they will eat you.
And they will eat you.
There you go.
And I think that's the same analogy of remaining vigilant, even if you're on the shores of a river.
Indeed. Wow. Okay.
You wouldn't think we could get so much from a proverb.
I
would you?
mean,
These proverbs are deep.
deep stuff, I tell you.
It can actually be a topic at some point.
Yeah.
I don't know what Lydia is doing.
You will force us to stand.
Yeah, clearly. Lydia has insisted that we must sing the national anthem this morning. But we keep it moving regardless. Right? So we're having this conversation this morning, and essentially, yes, justice is on trial, isn't it? I don't think at this point that there's a question about what happened to Albert. That he was murdered. He was brutally murdered. Number one, that the people who did this to him, there are many questions up in the air in terms of what happened, and in terms of, are there the beginnings, or are we in the throes of a cover-up, whereby those who would take responsibility for what happened to him are actually not taking responsibility in terms of the rights of humans, whether they're dead or alive. Those are very, very clear what they are. But justice is on trial here, and we are asking ourselves the question that how do we get justice to actually stand at the end of the day? We'll start off with you, Akili, because you are in court, and then you can also guide us in terms of what we can or cannot discuss, obviously. Before the day had even ended yesterday, we saw that this thing had turned on its belly, and the gentleman who was suspect number one then gave evidence to counter almost everything else that we had heard just on Monday, and that this happened after we saw the stepping aside of DIG Eliud Lagat. How does that change anything so far, or is it just testimony that will then be interrogated further?
Well, two issues come out very clearly. There is the criminal act of murder, where there are two only elements where the law looks for one. Did a person die? What is called the actus reus. Yes, Ajwang is dead. So the next thing the investigators are looking for, was there malice? Was there planning? Was there premeditated death? Or it was a circumstantial, incidental death? So the investigators must look for the evidence to show that before Ajwang was arrested and killed, there was knowledge and people agreed to kill him. That is the first burden. The second burden is whether Ajwang died in a police cell based on the circumstances found within a police cell. For example, Central Police Station, anybody who has bothered to go there, where the sentry is, as you come in, you get the sentry seated there. If then you are taken to a report office where your OB is recorded, the distance between the sentry and the main gate to the police, the main gate to the cells is around 15 meters. Then after the prisoner, this is a jargon the police use. Anybody in a police cell is called a prisoner.
Okay.
But English-wise, they are called either inmates or anything. Let's use the police term, the prisoner. The distance then, there is a holding ground an open space where advocates will meet their clients, where families can meet their clients, where it's an open space. It is another 10, 15 meters in terms of circumference. Then now the corridor that holds the cells. At Central Police Station, there are 6 cells. 3 on the left-hand side, 3 on the left-hand side. Then there's a corridor.
On the right-hand side, okay.
The first cell at the left-hand side is for the ladies, women's cells, which is permanently locked. Every time the inmate lady, the prisoners' ladies are inside, that cell must be locked. The second cell following is for the children, which is permanently locked. The third cell is for the men. It has no lock. It is an open cubicle. The 3 other cells on the right-hand side are for holding men. They are not locked. They were intended to be locked, but they were not locked. Then the last part is the abolition side. So the question that arises, a man in cubicle 1, cell number 1, can walk to cell number 2, can walk to cell number 3, can walk to cell number 4, but he can't access the cell of the children and the cell of the women. So the question is it new that prisoners inside police cells kill each other? It's not the first time. It just happened the other day. Is it new that prisoners, as they are called when they are in police cells, do commit suicide? So that is now one of the greatest puzzle for the investigator, IPOA, to get. Was Ajwang beaten by the people who are already booked inside?
Wakili, just a second, as you continue with what you're saying. So in Mukwana's statement, he actually says, I pointed out where the suspect was when he was pointing out to, referring to Ngige. I pointed out where the suspect was when then he entered the cells and came out to the following inmates: Colin Sireri, Amiton, Brian Moneki, and Eric Ndamboki. They took the suspect to the last cells opposite the toilets.
Yes.
So which of these ones is referring to? Because there's the women's, there's the children, and then there's the men's.
Last cell, I said, the first one is women,
Yes.
second one is children, the last cell is for men. Then there's the toilet. That is what he's saying. The statement of Mugwana, and I urge the country to be very careful with such statements, that statement has not been put to cross-examination. That statement, once it is tested in court, that is when the veracity of that statement comes in.
Okay.
The IPOA will record almost 1,000 statements. Others will record statements based on what they have been instructed to do. Others will record statement based on what they saw. Others will record statement based on what they hear. The quality of the statement, the quality of the evidence in a criminal procedure is when that is put to test. Then the quality of that statement will also come if it is collaborated by others. If it is an isolated statement that was recorded when others who were present are of a different view, that statement now becomes just a statement. I am not trying to criticize that statement, but I'm only advising as a lawyer that for now, IPOA will be told everything.
Okay.
IPOA will be told everything. IPOA must sit, and I've given the scenario. 1, the scene of the murder and the reason as to why the law in section 385, 386, and 387 and 388 of the CPC demands that any death in a police cell, circumstances must be established through an inquest, where the first complainant that triggered this process comes and testifies. Then anybody who was around, anybody who has information, anybody anywhere is allowed to give evidence in an inquest. The magistrate goes to the scene. Very many Kenyans don't know the scene I've given at Central Police Station. Then a finding is made. His finding says, Omari, all the evidence leads to you as the probable cause of the death of Ajwang. The file is sent to the DPP. The DPP looks at that evidence. Is it enough? Is it sufficient? Does it meet the threshold to charge under the decision called the decision to charge? If yes, then the DPP now says arrest Omari and charge. What we are doing now is a reverse of what the law says. And it is very easy in such an investigation to find a cover-up. Because Omari will be arrested and be said, Face is the killer. You cannot scream that arrest also so and so. But in an inquest, the public participates. Anybody who has evidence produces. And you saw it yesterday. We were raising it before the court that automatically this process is illegal. It is good politically that there are people arrested. It is good to keep the country interested that these things are going on. But the reality of the matter is that if, as it is, it proceeds, the killers might survive in the High Court when they raise the technicality that it was a miscarriage of justice.
Irongo, as we're looking at this, I think the question has come quite often, and we've asked, then why don't we see processes go as quickly as they normally would in another situation? And we've made the linkage in the last couple of days between when somebody else had, been murdered. Why do we see just such swift, and elaborate action? But here we seem to be people seem to be falling all over themselves to try and see reasons as to why questions are not being asked of certain people, the first complainant, for example, and things like this. Do we see that this flies in the face of human rights? And if so, justice on trial, then how does it get off the docks?
I think I think first of all we have to say that murder is a serious crime. It is obviously a homicide, and even if it is alleged that this was a case of manslaughter, there's the language of disciplining that has now begun to be introduced. These are still serious crimes, and given that it has happened in the custody of police officers and in a police station, it makes it even more serious. These are very grave crimes. So that's why you see the complexity and the attempts to cover up and the various dripping of information and the need for the public to remain vigilant and to continue pushing for this. And there have been some remarkable things that have happened over this last week. I think the release of the CCTV camera footage from Mbagathi was a major breakthrough. I think the speed at which Senate, summoned both the cabinet minister, the minister, plus the DCI, plus the IG. These were important moments, and the amount of interest that the public have in this case, I think, is really critical. Allow me not to get into the intricacies of legal strategy with the defense counsel for one of the accused, and Danstan.
Responded. They have not
responded. Not yet, yeah. We are at that stage. But he is representing one of the persons of interest in this case. And there is the question you asked earlier on, which is what is sub judice and what is useful for us to discuss. I want to go in two different directions, just responding to your comment. The first question we need to ask ourselves is we may now be a bit closer to what happened in that police cell. But obviously there are still questions about how this will play out in a court of law, and the court of law is much more important and powerful than a court of public opinion. But you need the court of public opinion to get the court to operate in the way that it should. But I think we are no closer to understanding why was he targeted. And I think African Uncensored yesterday did a bit of an interesting exercise of analysis where they basically looked at if Alfred was arrested alongside Kevin Mwindi for this false information charge that had been levied against them, and that they were somehow blowing the whistle on massive corruption within the police. And the defamation, as we heard from the Inspector General, was targeted against the complainant was Eliud Lagat. There's also the other name of a senior officer by the name of Joseph Chicher. The question, of course, is what happened to that information, and why were the accounts deleted prior to his killing. The hashtag Mafia Police is the one that I think most Kenyans have a lot of interest in. And if it is true that there is a cartel that leads to large amounts of money, I think 100 million shillings is the figure that we're hearing. So I think that line of inquiry needs to be focused on at this time as well. I'm not sure whether the Ethics and Anti-Corruption Commission is paying as much attention to this case as they should do. Maybe that's the first thing. The second one is yesterday we heard the Cabinet Secretary, the Interior Secretary, talk about terrorists and liken the people that went into the Parliament as terrorists. And I think as Amnesty International, we were dismayed once again that this language of terrorism, national security continues to persist in a context where I think what we have to recognize is the young people who were non-violent, who protested last year, were essentially very concerned about issues of governance. This has always, for us, been an accountability movement, despite the attempts by politicians and to some extent police officers who have tried to introduce violence and more radical extremist approaches. And I think the other side to this conversation, besides the conversation around why was Alfred killed, is the question of whether the multi-agency unit, the DCI officers that were sent to pick him in Homa Bay, were part of the agency, the multi-agency task force that has been set up, that has been responsible for the abductions of up to 89 people and 65 deaths last year. So I think that's the other inquiry that we need to follow up on, because I think unless we get into those conversations, then essentially we will be left with a case, which is important. And I think it's, I take the point Council is mentioning, that is talking about the need for the truth to come out in a court of law. But I think it's also important that we have the deeper reforms that are required to keep us in a space where we are confident that we have the leadership, we have the culture, and we have the operations that we see in the police force, that are the police service, that are lawful and they are governed by our constitution.
Now, Wakili, there is the aspect that you've brought up, which is on the matter of the process that is currently in court. And you say that with regard to what needs to be done, seems as though we're taking a different route, and that would mean this case would just fall on its face. Which begs the question, if that is well known and it is out there, why then does it seem as though we are following a different route, knowing at the end of it all, it's just going to fail?
Well, the state has two organs. There is the investigative arm of the state. That is the IPOA, the ESCC, the DCI, KRA, all those things. They do the investigation. It starts with a complaint. The DIG Lagat put up a complaint. And I want people to be very, very clear that there is no law that any claim must be put in an OB. We do every day letters directly to the DCI. And the DCI has no, for example, when a matter is reported to the DCI headquarters, there's no police station at the DCI headquarters. Those officers take up the matter, because once you do a letter to the DCI himself, Mr. Amin, he will appoint officers to handle that matter. So it's not true that you have got to do an OB when the DCI takes up the matter, especially when it goes to the DCI headquarters. I do them every other day. After the complaint has been lodged, officers are assigned to do the job. How they do the job, the complainant has no control on how they do the job. The officers do their job. One, if they do their job and commit a crime, they are held liable individually. Corporate responsibility, political responsibility is not found in any criminal law. The first time we have seen the concept nearer to political responsibility is in the Baby Pendo matter, where there is now we are invoking the act, the international law of the command responsibility principle, that the commanders must take responsibility. And this one, it is very, very sad news to the public, because the public will want the DIG to be brought down. Will be almost impossible, because the command structure of the police, the DIG only communicates to the directors or at the head office as the director of operations. He communicates his directions to the regional commanders. The regional commanders will cascade that to county commanders. The county commanders will cascade that to the OSPDs in their region. The OSPDs in their region will cascade that direction to the OCS specific to where the issue comes. So that chain of command is going to be a big impediment from the point of complaint to the point of execution. The officers who did, if at all, carry personal responsibility, because the police have instruments we buy for them. A gun with a bullet, a baton, as the weapons and the handcuffs, as the weapons lawfully given to them to execute their mandate. Ajwang was not shot. Ajwang was not handcuffed. Neither was Ajwang clobbered by either. There's a possibility it might have been a police baton, either not. So the question that we'll be raising anywhere in this trial is, was any officer given an illegal authority order to execute and kill somebody? If that the order was there, the officer could have shot. That is my analysis. And that's what we are saying. The process that most cases lose, and for the benefit of citizens, criminal matters, 90% are won because of failure to follow the Criminal Procedure Code, failure to follow the law as it is on handling of evidence. It is not on merit. Merit is Ajwang Albert is dead. If they poor, I understand they joined, they came to the office 2 to 3 months ago. If they do not follow due process, whether Ajwang is dead, it will. Look at what happened at the ICC. One prosecutor called Moreno Camp did not follow the procedural way of handling the Ocampo 6.
No, Wakili, since we don't have IPOA here, I have a quick question, because
Also, I think for a conversation of this nature, you would need all
could have
the
all the
counsel
counsel to be here as
We
well.
can wait for the court.
Yeah, because you keep referring to IPOA, and you're with IPOA in court yesterday. I just want you to break this down for me, because IPOA CEO said, confirmed that they haven't taken any statement from the complainant, and he said that they are conducting the investigation in a logical sequence, all right? And the reason they haven't started with the complainant is that certain facts are already clear. I want to ask you, as in this case, what I call you the defense lawyer, what are these facts that are clear on your end? Because we can't speak for IPOA because they are not here.
The only fact that is clear is that Ajwang is dead. That is not disputed. Scientifically, it has been proved by a pathologist that he's dead. 2, the cause of death has been established. Those are the only things that are clear. Others are investigatory in nature. And that is why Poa is right, saying they are going sequential the way the matter started. I have no problem with that. And I agree with IPOA 100%. Only 2 facts are clear: the cause of death and that somebody was dead. They will take their time. Had they, and that's what I'm saying, they can choose who to start recording statements with. If it was an inquest, automatically the first person to be brought as a witness is a complainant. But in a criminal investigation, IPOA takes according to the way they want. Nobody regulates them. What I'm only worried is it a cover-up that is likely to get the wrong people in the dock, and we defend them, we acquit them, the way the Ocampo 6 left the dock because the procedure was not followed.
So as we look at these issues, Irongo, you spoke earlier about why the court of public opinion is important in these things, and that we see that fortunately or unfortunately in this case, that you really don't have to look very far for things to become revealed, that every day we get something new that comes about, and then that is essentially is fodder. But there are many cases around the world, Rwanda that you mentioned being one of them, that when we look at order of command, that usually, sometimes, rather usually, in some of these cases, you will find that somebody may be put on the dock, not because that they were involved in something directly, but because they did give an order. The Felicien Kabuga case is one of those. And it's a very famous case in the sense that, you know, if somebody who is at a junior rank was given an order to do something, that the person who gave the order, whether it's alleged or otherwise, then is held liable. And we see that of an international nature of, you know, in the event that such a thing would then come about, why don't we see a push? And again, do we see that justice on trial here? Why don't we give a push for everybody along the line? We've heard, and like we said, IPOA is not in the room, so we cannot ask them why they have or have not. But it seems to be that it would just be a natural inclination to say, if names have been mentioned, if allegations have been made, then those individuals should be questioned with a matter of speed. Or no?
No. I mean, I think Kenyans are aware of the principle of command responsibility. It's been established for decades now. I mean, it's not just a key principle in criminal justice issues, but also in terms of conflict, where, you know, you have commanders of armies that tell, army officers to go out and kill civilians or to bomb, neighborhoods and so on. And the commanders are held responsible because that essentially is a dereliction of duty. It works two ways. One is they can be held responsible for acts of commission and also acts of omission, the failure to protect. So I think in this case, this will be a very important principle to follow through. And this is why I think, the DIG's stepping aside yesterday was so important, because I think once he has stepped aside, he can be summoned. I mean, I think he should have been summoned before he stepped aside, but I think it's now easier for them to summon him as a person of interest in this case and as a complainant. I think the other thing that, we have to look at more closely, which is the broader culture of policing. And, this case, I think, has just exploded so many things that we've been worried about for so long. The use of abduction, solitary confinement, and torture in the cases of the Longton brothers and Bob Jage. The use of solitary confinement for the bloggers that were arrested over Christmas, for example. The extended detention of Rose Njeri just 2 weeks ago. All of these are factors in how, what happened in Central Police Station took place. And I think it's important for us not to lose sight of the broader trend. And I think there are about four that are really important for me. The first is this idea that you should criminalize the right to protest. I think once you start going down that road, then everything begins to go wrong. We're now hearing in this particular case, allow me, I said I didn't want to get into the case very directly, but I think there's an important point around the allegation that there are what police officers call cacheros, people who are informants, who are part of the criminal underworld that are paid by police officers to do their bidding for them, and that there is an argument that 4 of them were essentially weaponized against Albert Ajwang in the court, in the cells. Police cells. The second area, I think, relates to, again, this multi-agency unit that has been operating for the last year. And I think we can't lose sight of that because we have heard it from the President, the Inspector General, the Director of Criminal Investigations, that they are not responsible for the abductions and the deaths that we've been seeing. So the question Kenyans still have to ask is who was responsible, who is responsible, and is somehow this connected to what has happened to Albert. In our view, to some extent, as Amnesty International, we are saying that the situation has become so murky and so unclear that I don't think we can do this purely in the courtroom. I think we have to have a judicial or a parliamentary tribunal that essentially unpacks this, and they will probably need international support, the United Nations or the AU.
Houghton, now, when you talk about matters to do with the criminal justice system, it is not just at the purview of the judiciary, but let's look at how investigations start, the process of arresting, documenting all these, and even just how we handle evidence. The police is very integral in a justice system that works. Yesterday, the Cabinet Secretary for Interior, Kipchumba Murkomen, gave a speech on police reforms that would be coming to place. And some of the things they talked about include installation of CCTV cameras, digitizing the OB, there is community policing, regular audits. But we are not lost from the start of the Kavuludi Commission with the police reforms and how far the country has come with regard to that. But then again, it seems as though the police is retrogressing and going back to the old days of a police force. So how do we then ensure as a public, as lawyers, as civil society, and as a country, that police serves as expected and that they play by the book? What will it take for us to see a police service that is working with the people?
Yeah. So, when the Kenya Kwanza administration came to power, they declared that they were not going to create a police state, that they were not going to weaponize the police service, that they were going to essentially restore the professionalism in the police service. And many of the leaders within the Kenya Kwanza had actually suffered at the hands of, I guess, what we used to call, actually now they've come back as Kamata Fridays, this idea that you can terrorize people using the instruments of the police. And I think what we have to recognize is that we have found ourselves back at that place. And therefore, there are a number of things that need to happen. So I did listen to the Cabinet Secretary yesterday afternoon, and there are a couple of things that I thought that would be useful as they think through the deeper reforms that are required. The first is the independence of oversight bodies is so critical. I mean, if we had not had the Independent Policing Oversight Authority in this moment, despite all the concerns we have with its capacity, imagine where we would be, right? I mean, who was going to police the police, right? So I think it's important that we return to the IPOA Act and we make essentially 3 amendments. The first is that we give IPOA the capacity to arrest. Right. The second is that we expand their jurisdiction, not just for police officers, but even officers of the Kenya Forestry Services and the Kenya Wildlife Services. We also need them, I think, to have a capacity to be able to hold KDF officers, because we have a situation in this country at the moment where the army is actually being used for civilian, what are traditionally civilian duties. We cannot forget that we still have the KDF deployed since last year. And if they're going to continue being part of the law enforcement architecture for domestic matters, then IPOA has to be responsible and provide oversight over that. So that's the first area. The second one, I think, this one is really tragic. We have a lot of Kenyans very concerned about the finance bill, and today there is potentially another demonstration that's been raised now. Of course, it took a different focus because of Langat, but I think it's important to recognize that in the finance bill, the amount of money that is being allocated to one of the most vocal and active of the independent offices and the constitutional commissions is just 0.5 billion shillings, and that is the Kenyan National Commission on Human Rights. Let me just contrast that a little bit. The National Gender and Equality Commission is going to receive 0.6 billion. Now, if you look at the weight of the mandate, I don't want to compare them, but I think it's important to recognize that the institution that has been most active in terms of documenting, abductions, deaths, and essentially educating the public and the government on what's been happening is the Kenya National Commission for Human Rights. Their budget has been slashed. The police, on the other hand, have a budget of 127 billion. So that's almost 200 times bigger than what the Kenya National Commission will receive this year. So I think, as the minister thinks about reforms, I think thinking about where the money needs to go, the resources, is critical. The third area, and then I'll come to this in a minute, is I don't think we as Kenyans will have confidence that justice has been done until we see officers held accountable for the abductions and the killings of Gen Z protesters. I mean, that is inescapable. When the president talks about accountability, this is the litmus test that the Interior Ministry and the National Police Service and the oversight authorities, this is what they have to do. They have to essentially not just disband the multi-agency unit, but they have to hold officers accountable for essentially serious crimes committed under our laws. I think these would be the issues. Now, of course, digital OBs, CCTV cameras in all the police stations, these are important investments to make. Training and retraining is very important. But the problem, that we saw in Central Police was not the absence of a CCTV camera. It wasn't the absence of a digital OB. It was the deliberate, avoidance of any documentary evidence in terms of how Albert was processed between Saturday and Sunday.
Wakili, I have a question. Actually, two very quick ones.
Yes.
And I would wish to get direct answers.
Very well.
I know you represent one of the clients,
Yes.
who is again at the center of all this, OCS Talam. But you, in your earlier statement when you started, you said the court will be weighing two things. One is establishing whether there was planning and premeditation of this murder, or two, it was circumstantial. In your reading, what are we looking at here at this particular moment with the evidence we have so far and the statements we have so far, including your client's statement? Number two, you also said that a case can easily, for lack of a better word, flop because of a technicality. These cases we are looking at it so far, because this case represents many other cases of many people who actually killed in police custody. This is just one of them. In this case, as the court is hearing all sides, what, in your opinion, is a technicality or technicalities that can actually end up creating what you'd call a miscarriage of justice?
Thank you very much. First and foremost, I will not be discussing elements of my client's case.
Yes.
There is a advocate-client's confidentiality. On the question of what is likely to be the Ocampo fiasco, where the real culprits go free, is when the agencies that are investigating, IPOA, fall to pressure of something called the public interest. And they bring people, because people's names have been said, bring Omari to court. What happened during Jesus' time. That if we will bring the people, because the public, which has no investigative capacity, to court, I'll assure you they'll walk out free. Let the due process, let investigations be done. There's nothing called a hurry. Members of the public, investigations are complex. Don't expect somebody to be charged tomorrow. But once the pressure, and my good brother knows how they push that pressure, once the pressure mounts, you'll find a wrong person brought to court. It happened at the quarry, where some women were found dead and their breasts cut. Pressure mounted all over the country. The people were arrested. That thing became a fiasco. In my own view, I think the investigators have They know what the due process is. Let them take their time. Let them tell the public that it will take time. It is not only in this country. Complex matters take time before somebody is arraigned in court. It is global. Because a court of law is very, very different from a court of public opinion. My other view, I'll ask my brother here. As we are paid to defend, the state does not have the feeling of the person who has died. The state works because it is created to work. Yesterday, the civil society, and the other day we were in court, they abandoned the family of Ajwang. Nobody. Because the question is not on the streets of Nairobi. The question will be in court. That is where the temple of justice is. I wish I was not a defense lawyer.
Deals kibao kila wiki na Carrefour. Enjoy Rina vegetable oil 5 liters at 1,069 shillings. Assorted 2-liter Pepsi, Mountain Dew, and Mirinda at 125 shillings. Von water dispenser at 710 shillings. And Medea fridge 173 liters at 29,499 shillings. Deals kibao kila wiki na Carrefour.
I appeal, as we defend clients, justice must be dispensed.
I hear
and
what-
justice and the family of Ajwang has equal representation.
So are you saying that what needs to happen at this point, and that we don't see that, is that there is no demand that the killers of Albert Ajwang are then brought forward and charged? There's no demand?
The demand is being bared in a fora that has no jurisdiction to make that order. The demand is in court. The evidence to nail who killed the person is not on demonstrations.
How does that need to happen? Because what you're saying essentially, Wakili, is that we're all here and there's conjecture flying around. If
Yes.
I'm not wrong, there's a lot of conjecture flying around that it is clear that Albert Ajwang is dead, number one. What else is clear is that somebody killed him.
Yes.
Right? But we are saying that no case, there is no complainant who is coming forth and saying, find the person who killed Albert.
The complainant is the state.
Yeah.
What I'm saying, in an adversarial system, the burden of proof of murder rests with the state. The state is such a big mongrel that has so many things to do. That is why there is the Victims Act, where my good brother and civil society comes in. They assist the state. The Kenya Human Rights Commission, that my good brother is seeking for more resources, could be coming to give more evidence to the state. They have a right to address the court. They have a right to bring these issues we are raising. In court now, what is left is the fourth estate, the media. It is the media that has no audience in a court of law. My appeal to civil society: come and watch brief, come and represent the family of Ajwang, because our theories will be theories to exonerate. We are trained to get the theories and the law to exonerate our clients. It is unfortunate. I am a Kenyan. I am a father. I am a husband. To see a young man lose life the way he lost life. And that is what I'm saying. As a Kenyan, I condemn the death of Ajwang. And I'm appealing for those whose mandate is to defend such vulnerabilities. Come on board, assist the state so that justice is done. I have no problem if my client is convicted, if he
Erongo,
did
yeah.
that issue.
Does the state need help, Erongo? In this case, is what we're saying, Wakili is saying that, well, that's great, but the state seems to have too much to do, and then we can't be able to represent.
No, my
Travesty of justice.
colleague is so passionate in representation of the victim. I'm not sure whether he's going to shift his attention from his client to the victim's family. I mean, that may be the other
For now,
option.
I cannot change because I've taken our instruction. You come on record.
With
before
a light touch.
Yes.
I think, let me just to reassure Dunstan that there will be representation, I think, for the family. So that's going to happen. And it's a good point. You're making ultimately a good point. I think the other thing that we should not lose sight about is, yesterday's, and I think you read it this morning, the statement by James Mukwana essentially says that he was instructed by OCS Talam
Yes.
on the instructions of the DIG. So that linkage, I think, will essentially, we can expect at some point DIG Lagat to have his time in court, essentially to plead his innocence or to lead, I guess, to inform the case a bit more. So I suspect that the DIG will this is not the end, but the beginning really of his involvement in this case from a legal perspective. I think the third thing that I wanted to just very quickly say is, the family of Ajwang continue to be supported by many of the young people. I think one of the things that really struck me over the weekend was his comment about he has lost a son, but he has found many children in Nairobi, and many of them are Gen Z leaders. And I think let's not put words in his mouth that he's been abandoned. He has actually felt the support of the Gen Z. My last comment, I guess, because I think we're at the hour, is today's demonstration. So I don't know if you'll allow me just to do a couple of things, because I do think in moments like this, we do need to provide some guidance so that people don't get, I guess, subjected to excessive police violence. And again, this will further complicate the reputation or smirch the reputation of the police service. So there are a number of things. I think there are some do's and don'ts for the protesters this today and in the weeks to come. The Law Society of Kenya have shared some of these. It's important that the protesters remain peaceful, that they have marshals, they respect not just bystanders, but other counter-protesters that might come, and look out for these cacheros or these goons that are now being used to create violence, and essentially citizens' arrest of those goons and handing them over to the police is what should happen. For the police, this morning Amnesty International and the Police Reforms Working Group will be releasing 7 guidelines to the police. They include things like, for example, it is the right of Kenyans to assemble. It is the right of Kenyans to be protected while they're in the process of protests. There are several cases that have been adjudicated, and we have rulings from the courts that essentially govern how the police can behave. So, for example, the use of masks, hoodies, and the absence of service badges, that is unlawful. The excessive use of tear gas and batons, that is unlawful. The ordering of police officers to break the law, in sense by committing acts of violence, that is unlawful. So it's very important for the commanders that are responsible for managing the peaceful protests over the next 2 weeks, that they essentially read some of those judgments again, because some of those judgments are now beginning to look for individual liability for commanders that give unlawful orders. And for the police officers, I think one of the things that we have to draw from this terrible case of Albert Ajwang is that when you are brought into a court of law, when you are summoned by the IPOA, you go there as an individual. So whether it be the officer Mukwana, or whether it be the OCS Langat, or whether it be the DIG, the OCS Talam or the DIG Langat, they are there in their individual capacity. They are not representing the police, and they will be held accountable, exonerated or convicted on the basis of their individual responsibility for what happened to the late Albert Ajwang.
As we wrap this up very quickly, I think what is on trial here is not just this particular case, but that it's the fears of people of what has happened previously that has gone unadjudicated, has gone unannounced, has bodies floating on rivers. This is the case. This is really this is representative not just of one man who died brutally, but things that have been happening historically that for which Kenyans are saying must stop. And if this is what it's going to take to put people in a position of accountability and responsibility, then so be it. The fear then also is that this will be another case where we're already hearing the rumblings of cover-up. Are we going to see another situation whereby somebody may be put up who didn't do this? Are we going to see another case whereby this will go through supposed process and end up in something that then just disappears? It's a fear, and we have to say it because it exists in the hearts and minds of many people. It's 5 minutes after 8 o'clock, and I want to thank both of you gentlemen for being here this morning. These are conversations that don't end, but they must continue. And even as we do, it's a wait and see, but we must be involved in these conversations. Danstan Omari, Irunga Houghton, thank you for being here this morning. Asante Sana.
Thank you very much.
Good morning at 5 minutes past 8.